I will now call case number 125754, State of Kansas versus Yeargin-Charles.
Good morning. May it please the court. I'm Ryan Ettinger, appearing on behalf of the appellant in this case, Mrs. Tashara Yeargin-Charles. With the court's permission, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Following the district court's denial of Mrs. Charles's motion to suppress, a Jackson County jury found her guilty of possession of methamphetamine, as well as an additional count of interference with a law enforcement officer. There were also a number of misdemeanor convictions that aren't really subject to this appeal at this time. The issue before the court rests on the district court's denial of Mrs. Charles' motion to suppress. The statute and the argument that we've made is that the officer in this case lacked reasonable suspicion to conduct the traffic stop that ultimately led to Mrs. Charles' arrest and conviction. The statute at issue is KSA 8-133, and that reads, every license plate shall be securely fastened to the vehicle to which it is assigned to prevent the plate from swinging, and at a height not less than 12 inches from the ground, measuring from the bottom of the plate. The license plate shall be fastened in a place and position to be clearly visible and shall be maintained free from foreign material in a condition that is clearly legible. What I've argued for the court in the brief and what before the Court of Appeals, but the brief in the Court of Appeals is that there is no reasonable suspicion here for the officer to conduct this traffic stop based on this statute. What we've argued is that this statute, first of all, should be construed and interpreted by the court for this no hanging or swinging provision to really be read all together as one statute and not as necessarily separate components. They all have some relation to each other, and the purpose of that is so that the plate is clearly legible. So an officer following from a safe distance is able to identify the vehicle. In this case, there is no question, no issue whatsoever that the officer was able to identify the vehicle and take the tag number. So that's sort of the first part of the argument. The second part is, even if the court disagrees with that, and that is a separate, and these are very, very separate, distinct requirements, and that part of the statute isn't really related to the other, then we will argue that in this case, there's no factual finding by the district court that this license plate was swinging in the terms of the statute. The district court, I'd focus the court's attention on the district court's memo in this case, where he said he only spoke about the officer's testimony at the preliminary hearing. At the preliminary hearing, officer only stated the vehicle or the license plate was only attached by one bolt and it was askew. He said nothing, the district court didn't make any factual finding that it was in fact swinging. And later at the suppression motion, there becomes this issue of, well, the officer now says it was flapping. So now if it's flapping, I've also argued that in the brief, if it's flapping, that's different than swinging. And I think there's also some issue with the Court of Appeals and the district court's reliance on the only way this has sort of been addressed before is through the federal court. The 10th Circuit has two opinions, Velasquez and Lopez Estrada. And the district court relied on those two opinions in its memo, finding that denying her motion to suppress. And what I've argued is that this court really shouldn't adopt those findings to interpret and apply this statute in this case under Kansas law. And I think there's some significant distinguishing factors from those two cases that I would like to direct the court to just quickly. In Lopez Estrada, there were actually, in both cases, there are two bases for the stop. So it wasn't just the license plate. There was also some other reason that was also upheld by those courts justifying the stop. Also in Lopez and Estrada, there was the officer observed that the license plate, I believe in this case, he was following the vehicle, observed that it was, the license plate was held on by a wire. And he testified that although it wasn't actually swinging when I saw it, I have seen plates attached in a similar fashion that as soon as there's some sort of wind, it will start swinging everywhere and make it illegible. Also, in Velasquez, the officer was traveling in the opposite direction. So he sees the vehicle at 70 miles an hour. And he sees the vehicle traveling the opposite direction and sees that the front plate is askew. And that court in that situation held that even though the officer was just unable to determine at that point, I see that condition and I think, well, maybe that might cause it to be unsecured. It might cause it to swing. So at that point, he had a reasonable suspicion to investigate. And so I think those two cases are distinguishable from the facts in this instant case. I don't think that the court should just hang its hat on those two opinions. And I also, in reviewing for this, I noticed that in the district court's memorandum of opinion, I was focused on these two 10th Circuit cases. But at the bottom, the district court does have a but C and cites a case from Vermont in his memorandum opinion, which is kind of, I don't know if the court didn't want to go all the way, district court didn't want to go all the way through an analysis and just kind of well, here's a but C. But that case is a Vermont case. And in that case, I think it's State v. Tuma. It discusses how exactly what I'm asking the court to do. And it looks at the Vermont statute and says, well, these requirements of how it's affixed and the question exactly.
Driving down the road.
Right.
Was there, you've argued there's no evidence of swinging. Was there any evidence of an insecurity?
That's the other point, Your Honor. And that's exactly, I mean, obviously there is some security question here of safety, a traffic safety matter. That didn't happen here, but yeah, I don't think there's anything, there's nothing here in the record to show that it was unsafe. There is a photograph of the license plate itself in volume 1, I think page 85 or 90 or something. But anyway, it just shows it being askewed and it's fastened by one bolt. I mean, we're all familiar with that sort of, it's not a tiny little bolt, it's a decent sized bolt that goes into that license plate. That license plate is a rather heavy gauge.
Your argument is
it's not
that if
safe.
the bolt is securely cinched down, then right. The plate is secure. It's
secured, right. And to the extent that it's and the facts were here that it's not moving everywhere. It's not swinging in a manner like the statute says swinging. Well, you think about, well, like in this case where it's tied to the vehicle with a wire or, I mean, clearly the legislature doesn't want you to flip it over, right? Just married on it and trail it behind your vehicle somewhere. So I think to the extent that there's a safety concern, that's not present here at all.
Did the detective or deputy Dobler, okay. Did he testified that it was moving while the vehicle was traveling, and he said like flapping in the wind, so to speak?
Like it was moving back and forth from the vehicle to the back of the vehicle, from the vehicle to the back of the vehicle. What's interesting is, like I said before and argued before, the district court never doesn't go down that road in its finding. It relies on what the officer's initial testimony was before the court at the preliminary hearing, when all he said was it was fastened by one bolt and it was askew, and I found that to be a violation, which is not a correct interpretation of the statute. There's no, and like in the Vermont statute for issue, the requirement is that it's horizontal, and there's nothing like that in our statute. It could be vertical, it could be horizontal, it can be as long as it's securely fastened. And in this case, the best evidence of that is the officer following behind the vehicle and it's barely moving. So I would argue then that it's securely fastened. It's not going anywhere.
So we would presume that finding was made, that it was swinging, and then you're asking us whether or not there's substantial competent evidence to support that implicit finding?
Right. I don't think there's substantial evidence because the district court never made that factual finding. And the district court didn't say, I looked and there was a dash cam video. And the district court didn't say, I looked at the dash cam video, even though it was urged to by the state at the suppression motion. I looked at this dash cam video and I'll just make a clear factual finding that this thing's swinging, and that violates the statute. But the district court hung its hat on, well, the officer testified during the prelim that it was askew. It didn't have both bolts. And there is some discussion about that during the suppression motion. They go down this sort of road of, well, my bumper looks like this and I should have 2 bolts and 1 bolt. So that seems like the state even at that point was somewhat confused about what the actual law was. Now there's no driving at this. Okay, we're gonna put on proof of swinging. That never happened. So does that answer your question, Your Honor?
I think so. Thanks.
Unless the court has additional questions for me. Thank you.
May it please the court, Chris Slugger, Deputy Solicitor General, appearing on behalf of the state. And I'm here to tell you that the Court of Appeals got it right. The plain language of the statute says that the license plate must be securely fastened. And we had the testimony of the officer from the suppression hearing said the vehicle's registration plate was loosely secured by a bolt or a screw on the left side in the manufacturer's hole and was tilted downwards to the right, slanted downwards to the right, not secured by anything, and moving. He said the plate was obviously moving while it was traveling. And later he said it was flapping in the wind. I think that meets the plain language of the statute.
We all live here on the windy plains, and we're probably familiar with being out in strong winds. If I drive past an intersection, the stop sign intersection, and say, boy, that stop sign was really flapping in the wind, does that mean the sign is not secure?
Well, I don't know. I don't know that there's a statute that.
Well, there isn't, but it seems that
the sign is sticking up on a pole in the wind. A license plate is attached to a car, supposed to be securely fastened to the car, to the back end.
Well, that's what we're here to try to decide, whether there's any evidence of it being insecurely fastened and or swinging. And I went through the whole transcript. Swinging doesn't show up once.
Yeah, but the officer said it was flapping in the wind, and I know there's been arguments that that's not the same as swinging, but
well, why can't a license plate, maybe not in this case, but just hypothetically, you I think would agree that you could have a license plate that is very securely fastened, which could still flap in the wind.
I mean, I can't say it's not in the realm of possibilities. I'm having a hard time considering that, because up against the car, if it's securely fastened, it shouldn't be flapping. It's not like a stop sign that is standing up on a pole exposed to the wind. Up against the car, it really shouldn't. If it's securely fastened,
whether or not it should be flapping is irrelevant. The question is that evidence that it's not securely fastened?
And I would say it is, because otherwise, I think you're asking for the officers to use like talismanic language to say that it was swinging as opposed to flapping in the wind or any other.
No, I'm trying to
English
discern
language.
what the statute actually prohibits. And I don't read in the statutory language a prohibition on a 1-bolt license plate. And that's essentially what this case comes down to.
Well, it comes down to really what does securely fastened mean.
Right.
And the state.
And so why can't someone securely fasten their plate to their car in an askew position with 1 bolt?
Because I think the askew position and the flapping in the wind indicates that it is not securely fastened.
Does that pass the common sense test?
I think it does. I mean, I could say, I mean, is it possible to get if you took 1 bolt right in the middle of the license plate, maybe that would be securely fastened. But if it's hanging and it's moving and flapping in the wind, at least that gives the reasonable suspicion that it's not securely fastened, because that's what we're really here about, is does the officer have reasonable suspicion? Taking your analogy or your hypothetical to the end there, I mean, I suppose it could be possible that the officer could get up there and say, oh, well, gosh, this license plate really is securely fastened. I mean, doubtful, but he doesn't have to know for certain. He just has to have a reasonable suspicion. And if he sees a license plate hanging askew and flapping in the wind, I think it's reasonable for him to.
Can't we read into the language the legislature chose, because they chose the word swinging? Can't we read into that reasonably that what they were concerned about was rotation around the screw?
Well, I
And
think
flapping
we're
doesn't-
parsing the word swinging too much. To me, I think flapping in the wind indicates something
So you
similar.
just want to be like close enough, swinging, flapping, whatever.
Well, again, I think if you're trying to get the officers to use talismanic language to say, oh, I saw it swinging. When he says, I
It's
saw it
not
flapping.
talismanic, it's just ordinary speech. Again, I'll go back to my stop sign. I think that's very common to talk about a sign flapping in the wind. It's very
Moving.
uncommon to talk about a sign swinging in the wind.
Well, but swinging is a kind of movement. I mean, how many different words could we use to describe swinging? I mean, you're asking the officers.
Is that really true? I mean, doesn't swinging mean that an object is rotating around a fulcrum? I mean, isn't that what that word means?
Moving.
No, it doesn't mean just moving.
Well, I think in common parlance, if the officer sees a license plate hanging and flapping in the wind, to him, that's swing, whether it's
Okay.
swinging this way or this way, it's swinging, it's
Okay.
moving. And
But
it's
you're-
not, and the ultimate thing here is it says securely fastened.
Right. In your, just to sum up this line of inquiry, you're staking your case on the testimony about hanging askew and flapping. You're not arguing that there was something more than that.
I don't believe there was. Now, I'll have to admit that I came into this, I'm pinch hitting. The original attorney on this case has moved on to other employment, so this fell into my lap. Not 100% up to, I don't have the record 100% in my head. I'm relying on that and what's in the briefs and what I think what the Court of Appeals said was relying on that. And I think I would point you to the federal cases that have already looked at this very statute here in Kansas and essentially agreed with the state. I realize they're not binding. You know, the 10th Circuit is only persuasive, but you know, the Lopez Estrada case, there's even, if you look at the Westlaw, I looked up on Westlaw, there's even a picture there of the license plate and it's just sort of hanging a little bit, similar to what was described here. And they said that was sufficient to provide a law enforcement officer with reasonable suspicion. And I thought what was kind of getting back to what I was trying to say earlier is that the 10th Circuit said that the Fourth Amendment doesn't require a law enforcement officer to actually see the plate swinging to stop the vehicle. He only needs a reasonable basis for thinking that an infraction has taken place, and a hanging license plate is sufficient. So again, whether it actually is securely fastened or not, is it reasonable for the officer to believe that it's not securely fastened? And I would submit that seeing a license plate attached by just a single bolt, hanging and flapping in the wind, is enough to lead a reasonable police officer to think, hey, we've got a violation of the law here. The license plate is not securely fastened. And so obviously that's a reasonable basis to make this stop. And therefore the district court was correct in not suppressing the evidence, and the Court of Appeals, like I said, got it right. If there are no other questions, I would simply ask you to affirm the Court of Appeals. Thank you very much.
Thank you.
I think unless the court has any specific questions, I'd be willing to yield the remainder of my time on rebuttal.
What about counsel's highlighting the testimony that the deputy said that the registration plate was not just secured by a bolt, but it was loosely secured?
I think
I mean-
that's his opinion. There's no evidence in the record whatsoever that.
What's his
You know, it's like if
testimony?
we had a
right?
demonstrative exhibit and we could test how far I can put the screw in and can I yank the plate off, then it would be unsecured. But there's nothing in the record to support that testimony from him. And I noticed that his testimony, as we go from the preliminary hearing, which it seems like his understanding, that officer's understanding of the statute was that it was violated by the plate being askew and only one bolt, to now we're starting to get closer to, he never actually testifies that it's swinging, but now he's getting closer and closer. He's saying the right words now, that he's in the form of getting inside the statute of saying that, well, it's loosely attached. Furthermore, I'd also say that the state says, and even to the degree of moving, the state points out to the district court that you need a keen eye to see it. And it's nighttime, 3 o'clock in the morning. But if you look really close, you can see it moving. And I think that might be, and clearly the district court wasn't persuaded by it. So, because it hung its hat on, as I said, on the officer's testimony at the preliminary hearing. So I think to the extent that there's some indication there now that the officer is saying that it was loosely attached by the screw, there's just nothing to support that beyond his just statement. Unless there's further questions, I appreciate the court's time this morning, and we just ask for a reversal. Thank you, Your Honors.
Thank you. Thank you to both counsel for your arguments. The court will take this case under advisement.